Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. Today we are going to learn about an OBITER Dicta by a Kerala High Court judge regarding education, regarding Pocso Act and its consequences, or in other words we can call it as sex education in the school or college level to the students. Why this thing happened? First of all, you must know what is OBITER Dicta. OBITER Dicta means passing remark. Of course, it does not find any place in the judgment. It has no straight relevance to the judgment, but still it is an opinion, honest opinion by the judge. Of course, it may be followed or it may not be followed. Recently, on 8th June 2022, while disposing the bail petition of you can read the case as Anoop versus State of Kerala 2022 in criminal miscellaneous petition number 3273 by 22, right? So this relates to crime number 183 by 22 of Uttapalam PS of Kerala State, registered under different sections 9 and 10 of the Pocso Act, as well as section 376 IPC also. You all know that the Pocso Act, that is Prevention of Children from the Sexual Offences Act, it is a very stringent act and punishment is 100%. Conviction will be definite if the prosecutrix sticks to her version because of the sections 29 and 30. It gives reasonable presumptions. So the court shall presume that unless she contradicts, definitely the incident happened, and it is for the accused to defend himself. It is very impossible, almost nearly impossible. Right. So here, what is happening in the society? This is the observation made by Justice Thomas. Without knowing the consequences, without knowing the importance of the Pocso Act, children, or particularly the adolescents, that is people between 14 and 18 years, they are involving in the so-called sexual activities which land them in trouble. You may be knowing, even as per section 376 IPC and also Pocso Act, a minor, even though she gives consent, it is not at all consent. If consent is obtained by fraud, like that we discussed. But anyway, so if anybody commits rape on a minor, definitely it is liable under Pocso Act as well as section 376. So the punishment may be up to 10 years or it may extend to life also. So without knowing the consequences, people are landing in troubles, particularly young generation. So therefore, it is high time, in the view of the court, that the court has to explore certain methods to direct the education department to make it a part of the curriculum. Therefore, the Honorable Justice has made the Higher Secondary Board and the Education, Graduate Education Secretary, all these people as the respondents and directed them to make efforts or to make a framework to see that the sex education, particularly to the adolescents, is made a part of the curriculum in their syllabus. Of course, it is for the state whether to follow or not. But please remember the words of the court. Time has come for the court to step into the explore the possibilities of methods in various possibilities to install the so-called education to the people, particularly to the adolescents. So this is a very good decision. Actually, while dealing with the Pocso Act also previously, even I made a video, I don't remember the date, about 1 year back. So the children should be taught about the good touch, the bad touch. So normally we are seeing the defenses whenever the person, age-old person, is accused of molesting a minor on the Pocso Act. He says that he has just kissed her or he has lifted her or he has hugged her in a fit of like the grandparenthood, like that. So out of love and affection, so you must differentiate the good touch and the bad touch. Then only things will happen. Anyway, good decision. But please remember here, the legal maxim also the court cited, ignorantia juris non excusat. ignorantia juris non excusat means ignorance of law cannot be excused. Innocence of law, to some extent, it may be excused, but still, the court found it, please remember, irreparative to see that the children involved in such cases, they cannot be excused. So, very good obiter dicta. Actually, it has found place in the judgment bail order also, but it has no relevance to the judgment of the case. But it is the actually opinion, or it is the feeling of the judge. So anyway, the state, if allows the same, and if it makes sex education or education regarding the Pocso Act as a part of the curriculum, definitely I hope it will reach good results. So please read the case law Anoop versus State of Kerala 2022, by which you will enrich your legal knowledge. Thank you very much.